Hello friends, today's my topic is about public interest litigation. When the public interest litigation came into force, or the first case when the public interest litigation was being taken into account, or who will be treated as the father of public interest litigation. Justice P.N. Bhagwati is known as the father of public interest litigation. The public interest litigation is a petition in a writ petition where a person who don't have any personal interest on that subject, who is a social activist, when he files a writ petition about a particular issue in society, that will be treated as public interest litigation. Means no personal interest should be there, one who files a petition. And under what article the public interest litigation can be filed. And when the public interest litigation was started, for the first case before the Supreme Court, it was in the Bandhu Mukti Morcha vs. Union of India and others, AR 1984, SC 802. Justice Bhagwati, Justice R.S. Pathak and Amrendra Seth judges. It was a case where a letter was being written by a petition organization dedicated to course of release of bonded laborers to Chief Justice of India. Treating the application as petition under Article 32, the court straight away appointed a commission to visit the quarries located at Gadkokar and Lakarpur in Farizabad district, and after obtaining the report issued notice to the parties and the Union of India on the measures to be taken for granting relief to the bonded laborers. The judgment was delivered by Justice Bhagwati. Under Article 32(1), the right to move the Supreme Court by appropriate proceeding for the enforcement of the rights conferred by this part is guaranteed. Part 2. The Supreme Court shall have power to issue directions or orders or writs, including writ in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, where may be appropriate for the enforcement of any right conferred by this part. While interpreting Article 32, it must be borne in mind that our appropriate approach must be guided not by any verbal or formalistic canons of construction, but by the paramount object and purpose for which this article has been enacted as a fundamental right in the Constitution. And its interpretation must receive illustration from the trinity of provisions which energize the entire Constitution, namely the preamble, the fundamental rights, and the direct principle of state policy. Clause 1 of Article 32 confers the right to move the Supreme Court for enforcement of any of the fundamental rights, but it does not say as to who shall have this right to move the Supreme Court. So that is the Article 32 under which the public interest litigation can be filed before the Supreme Court. And Justice Bhagwati was the presiding judge of this particular judgment, where the writ petition was admitted and order was being passed. And it was about a public who was the Article 32 says that the Supreme Court can be moved for enforcement of fundamental right and appropriate proceeding. There is no limitation regard to the kind of proceeding envisaged in clause 1 of Article 32, except that the proceeding must be appropriate, and the requirement of appropriateness must be judged in the light of the purpose for which the proceeding is to be taken, namely enforcement of fundamental rights. This is the point. The Constitution maker deliberately did not lay down, and particularly for the proceeding for enforcement of a fundamental right, nor did they stipulate that such proceeding should conform to any rigid pattern or straitjacket formulas, for example, in England, because they knew that in a country like India, where there is so much of poverty, ignorance, illiteracy, deprivation, and exploitation, any insistence on a rigid formula of proceedings for enforcement of fundamental right would become self-defeating, because it would place enforcement of fundamental rights beyond the reach of the common man. And the entire remedy for enforcement of fundamental rights, which the Constitution makers regarded as so precious and invaluable, that they elevated it to the status of fundamental right would become a mere rope of sand. So far as the large masses of the people in this country are concerned, the constitution makers therefore advisedly provided in clause 1 of Article 32 that the Supreme Court may be moved by any appropriate proceeding, appropriate not in terms of any particular form but appropriate with reference to the purpose of proceedings. That is the reason why it was held by this court, the judge's appointment transfer case, that a member of a public acting bona fide moves the court for enforcement of fundamental right on behalf of a person, class of person who on account of poverty or disability or socially or economically disadvantaged position cannot approach the court for relief. Such member of the public may move the court even by just writing a letter, because it would not be right fair to expect a person acting pro bono publico to incur expenses out of his own pocket for going a lawyer and preparing a regular writ petition for being filed in court. For enforcement of the fundamental right is a poor and deprived section of community, and in such a case, a letter addressed by him can legitimately be regarded as the appropriate proceeding. This was the judgment in 1984. Prior to that, the judgment about public interest litigation was pronounced in the year 1982. In the year 1982, in transfer of High Court judges, absolution addition charges, the first, the S.P. Gupta and others was a Union of India and others. In that matter, T.N. Bhagwati Justice gave a judgment. The public interest litigation or locus standi of filing writ petition was been taken into account. The fourth point in the judgment was the court must allow its process to be abused by politician or other to delay legitimate administrative action or to gain a political object. That was the point. Andrew Rabia has warned that political pressure groups who could not achieve their aims through the administrative process, and we might add through the political process, may try to use the courts to further their aims. These are some of the danger in the public interest litigation which the court has to be careful to avoid. It is also necessary for the court to bear in mind that there is a vital distinction between locus standi and justiciability, and it is not every default on the part of the state or a public authority that is justiciable. The court must take care to see that it does not overstep the limits of its judicial function and trespass into areas which are reserved to the executive legislation by the Constitution. It is a fascinating exercise for the court to deal with public interest litigation because it is a new jurisprudence which the court is evolving. Jurisprudence will demand judicial statesmanship and high creativity ability. This was the first judgment in which public interest litigation of locus standi to file a writ petition was being questioned, or the Justice Bhagwati in that judgment 1982. He has clearly, categorically and clearly stated what is public interest litigation or who has the locus standi to file any writ petition to invoke under Article 32 or Article 226. Then public interest litigation was firstly been raised, or the locus standi was first time being questioned or raised or subject of jurisprudence was mentioned in that particular judgment. Subsequently, the judgment just now I told you about labor's rescue and all. In those two, that was the further where the public interest litigation was being taken into account by the judiciary, where it was very much be cleared by the judiciary that by even a envelope or a letter addressing to CJ of India, the letter will be treated as a writ petition or public interest litigation, and the court can direct the concerned authorities to make into the inquiry and fire counter, thereby granting any appropriate which is to be good or to in the public interest. when the public interest or fundamental rights of any person in the total was been tampered or overridden by anyone, the public interest litigation can be filed by person who is not at all been interested party to that particular issue. Thank you very much, friends. My name is Srinivas Advocate. Thank you for watching my video.